And on to the next session. This time we're going to talk about the procedural issues in suing corporations for climate change contribution. The chair of this panel is Attorney Gregorio Rafael Bueta. So, Attorney Grip, as he is commonly called, is an environmental, climate, and sustainability lawyer who has worked with governments, private sector, and various international organizations on leading law, environment, and climate issues. He is a member of the IUCN World Commission on Environmental Law. He lectures on natural resources law and international environment and climate law at the Ateneo Law School, and he is an off-counsel of the Magtibay Law Office, a fellow of Parabukas Inc., and legal consultant of Eco Waste Coalition. So he's going to chair the next panel, which will talk about the procedural issues in suing corporations for climate change corporation. Joining him in this panel will be Attorney Gertie Mayo-Anda as well. Thank you for your service, Attorney Gertie. Double work ka ngayon. And our very own Professor Donna Zapa-Gasgonia. She graduated from the University of the Philippines College of Law. She received her Master of Laws degree in Canada. She's an AB Philosophy graduate, cum laude of the UP College of Arts and Sciences. She's a practicing lawyer and supervises the Environmental Litigation Clinic of the UP Law Clinical Legal Education Program. She's a lecturer of the UP Law Center Institute for the Administration of Justice, MCLE, for lawyers on the subject of prosecuting environmental cases. So, joining us online is Attorney Mie Asaoka. Attorney Asaoka was born in Tokushima Prefecture in 1947. She graduated from Kyoto University Department of Law in 1970, and she is registered as a member of the Kyoto Bar Association in 1972. She participated in consumer lawsuits relating to SMON, it's hard to pronounce, Minamata Mercury poisoning case, and the Toyota Shoji big fraud cases. She was chair of the Consumer Issues Committee of the Japan Federation of Bar Associations in 2001. She's also president of the Kyoto Bar Association in 2006. So can we flash her on screen? Oh, there she is. Good afternoon, Attorney Mie Asaoka. Also joining us online is Shri Ritwick Dutta. Ritwick Dutta is an environmental lawyer and founder and managing trustee of the Legal Initiative for Forest and Environmental Life. It's a public interest environmental law group which focuses exclusively on environmental litigation and has supported communities, civil society groups, and affected citizens in bringing environmental issues before the court. LIFE, or the Legal Initiative for Forest and Environment, is the recipient of the Right Livelihood Award in 2021, which is also known as the Alternative Nobel Prize for its innovative legal work, empowering communities to protect their resources in the pursuit of environmental democracy in India. So can we flash Shri Ritwick Dutta? Is Shri Ritwick Dutta online already? Okay. Okay. Also, as a panelist, and he's now in person in the theater, is Attorney Ryan J. Roset. May we request Attorney Roset to join the other panelists in front. He obtained his Juris Doctor degree from the Ateneo de Manila University School of Law in 2006 and his Master's in Law in Constitutional Politics, Law in Theory at the Birkbeck College in the University of London under the Chevening Scholarship Program. After a brief stint in a senior public service position, he hightailed it into developmental lawyering. Since 2020, he has devoted his energies on working on indigenous people's rights, environmental rights, and human rights. He now currently serves as the Legal Rights and Natural Resources Center's Senior Legal Fellow. We also have Honorable Jesus G. Torres, Municipal Trial Court Judge at Large, in the panel, but he currently has a hearing and he's going to catch up, right? So it's all yours, Attorney Grip.
Thank you. Hello, can you hear me? Okay, yeah. So thank you very much. Magandang hapon po and good afternoon to everyone. I know this is a very challenging and difficult time to hold the session. Not just because it's after lunch. I know a lot of you want to take your siesta, but especially since we had a very interesting session earlier on human rights. And I think it sets the presentations earlier by our CHR chair, by Yeb and the others, by Attorney Jerty. So double duty po kayo, Attorney Jerty. And by the others, I think sets the tone for our session this afternoon. I know Ritwick is just in court. I don't think he's online yet. He sent an email. Yeah. Knowing Ritwick, I've known him for several years. If you can't find him, he's most likely in court. That's the joke among him. He's logging in. Okay, he's logging in. Okay. Let me start with a short opening remark. So, thank you for joining us here on site and for those online for this panel 2 on getting to court procedural issues in suing corporations for climate change contribution. So again, I am Attorney Gregorio Rafael Bueta. I come from the other law school, as Justice Leonin said, no? But of course, I cannot. I have to say yes to Prof. Mike, and I cannot say no to this invitation to be here. And I've been tasked to chair this exciting and critical session, I think, about courts and procedural issues. For me, it is really an honor to be in the presence of this esteemed panel of experts. Individuals whose experience span decades, from early years of the environmental law movement to present-day challenges of climate change and corporate accountability. Not to yung age po ng mga kasama natin, but I think as you have said kanina that and what Attorney Oposa said earlier, the challenges that they had before, kailangan 10 times mas eager tayo, but I think now it's 20 or 30 times more tayo. More importantly, these individuals continue to serve as inspirations to once young lawyers like myself and future defenders of people and planet like many of you here today. The role of courts in addressing environmental issues and now the climate crisis and emergency cannot be understated. Courts are the bastions of justice, the defenders of fundamental rights, like the right to a clean and healthy environment. Judges in the judiciary also exact accountability on duty bearers, be they states, individuals, and of course, the topic of this afternoon, corporations. Climate change and its resulting impacts are increasingly being brought before courts as part of wider climate action and calls for climate justice. So today we will answer these critical questions. Are courts ready, and are our procedural rules up to task or up to these challenges? Okay, so without further ado, we'll now move on to the opening remarks of our esteemed panel. May I start with one of my many idols in the environmental law movement, Attorney Jerty, with your opening remarks. Please.
I have a few slides which is actually related to the National Inquiry on Climate Change. Can we show that? Okay ba? Okay, this is the climate justice journey. You've heard much about it, but I'd like to share with you that In 2014, okay, thank you. In 2014, before the petition was filed, we had the meeting, Greenpeace organized a meeting of environmental lawyers, including Attorney Oposa, ELAC, LRC, Ateneo School of Government, and the alternative law groups to present the report of Dr. Richard Hidi, the carbon major study. And we had some deliberations on whether it was already timely to utilize the rules of procedure for environmental cases to actually initiate action based on the carbon major study. And there was some hesitance because of the fact that the science of attribution or attribution science was not yet captured in our rules. Okay, that was the question then. So then there was an interest to look into the human rights aspects of climate change. So hence the petition in 2015 was filed. It was labeled as 2016. Okay, so there were actually 2 major NGOs, 12 other NGOs, and then 20 individuals. And there were more than 100,000 people all over the world who signed, who gave support to the petition. Okay. Is it this way? Okay, the next slide. Okay, so this is the issue. And that was what the CHR was also grappling at the time, whether these respondent carbon majors who actually substantially contribute to the greenhouse gas emissions all over the world, and they have failed to curb their emissions despite their knowledge and their capacity to do so. Should they be responsible for the human rights implications or the human rights violations resulting from the climate harm? Okay. And then, these are the prayers. I will not go one by one, but one of the things that we actually sought here was to request the carbon majors to submit plans. And actually the NICC resolution adopted that, including effective accountability mechanisms. Okay? So there are 5 important things that we highlighted, that while climate change is real, it is impacting the Philippines and Filipinos disproportionately. We are very most vulnerable. I think our experts this morning tackled that. Second, that it results and threatens the impairment, infringement of human rights. So there were experts who articulated the results of their studies. We had experts from the government, from institutions, from scientific institutions, and many others, including biodiversity specialists. And then the contribution of the companies, okay, the carbon major study. It was gratifying to see Dr. Richard Hidi flying over, coming to the Philippines and being present before the Commission on Human Rights. And the fact that these actions of the carbon majors or inactions are linked to climate change and continue to threaten the Philippines until now. And finally, that the position that these companies are responsible under various laws, international and domestic, and they are obliged to respect and protect the human rights of Filipinos in the context of climate change. So I will end with that, just to summarize the fact that this is a group of citizens who sought redress outside of the court. Thank you.
Thank you, Attorney Jerty, for giving us some additional information about the climate change case, which you were one of the
Yes.
lawyers in that case.
I'm privileged to have been one of the lawyers
One
involved.
of the lawyers.
Thank you.
Thank you, Attorney Jerty. May I now turn over to Attorney Ryan, or who we fondly call Roset. Attorney Roset, yeah, for your opening remarks. Thank you.
Thank you, Grip. So, yeah, I'll just read my opening remarks. So the fundamental point of departure of any Philippine climate case is the right to a balanced and healthful ecology. That right, as articulated in UPOSA, considers the rhythm and harmony of nature. Nature means the created world in its entirety, close quotation. So UPOSA therefore implies several things. First, that man is part of nature. And second, that nature is fundamental and inextricably linked to man's survival, and even the state. The right to survive, which is a basic human right, likewise gives birth to the duty to protect nature. Notwithstanding Oposa's profound articulation, there appears to be a dearth of cases which solely invoke this right as a basis of a cause of action. Rather, most of the cases are couched generally as environmental cases and premised on command and control environmental laws, which really are insufficient to capture the gravity of the climate crisis and the right to a healthy climate. For instance, a corporation that complies with air quality emission standards, that does not necessarily mean that it is not significantly contributing to the climate crisis. Another issue is attribution. Under the current Philippine legal framework, there is no clear pathway to hold anyone responsible for contributions to the climate crisis. In traditional environmental cases, plaintiffs have been challenged to prove the violations they suffer and the causal relationship between how particular corporate activities are contributing to environmental damage. This exposes an urgent need, policy to enable the courts to better address climate change controversies. It is well established that certain industries, particularly the fossil fuel industry, bear substantial responsibility for the climate emergency, which can be traced to the extraction and processing of carbon fuels. The industry and others similarly situated, therefore, are in the best and strategic position to address the climate emergency. Without risk of sanctions, they, however, have no incentive to change the current situation. Corporate interest is to maintain the status quo and preserve their profit margins. Moreover, attribution of responsibility is a thorny issue. Communities are left to bear the brunt of everyday effects and colossal catastrophes brought about by climate change while having little to no means to mitigate these. Put differently, even though issues concerning the climate crisis are universal, capacity to mitigate the impacts and risks are not. Poor communities are far more precariously situated in a climate crisis. Intimately related to the issue of attribution is the concept of damage or injury from a climate change perspective. Damage has been traditionally defined as a detriment, injury, or loss which are occasioned by reason of fault of another in the property or person, which entitles the injured party to claim from the person who has committed injury. It has also been jurisprudentially defined as the loss, hurt, or harm which results from injury, and damages are the recompense or compensation awarded for the damages suffered. This notion of damage or injury, however, limits any cause of action for climate litigation to climate change impacts, and not to the anthropogenic and quantifiable contribution to climate change, which inevitably, although not necessarily immediately, leads to climate impacts such as changes in rainfall, resulting in more floods, droughts, or intense rain, as well as more frequent and severe heat waves. This notwithstanding, the case of Sangakala versus NPC, as penned, I think, by Justice Yonen, opined that environmental harm may include immediate and future physical injury to people, emotional distress from fear of future injury, societal and economical disruption, remediation, cost, property damage, ecological damage, and regulatory harms. Viewed from Sangakala's perspective and in the context of the recently embedded concept of future inevitable harms under the Philippine legal context, it may be well worth to re-articulate and expand the concept of damage for proposed climate litigation to impairment of climate itself. Such re-articulation serves to enlarge the scope of possible claims and cause of action beyond those suffered during climate change impacts. Okay.
Thank you, Attorney Roset, Attorney Ryan, for the opening remarks. I think you touched upon some very important points on attribution. I will try to look into that later as we look at our procedure rules. And also, communities being left to deal with climate change. So, as I said earlier, it connects well with the previous session on human rights and climate justice. May I now turn to Attorney Asaoka, Attorney Mia Asaoka. Could you hear us, Attorney Asaoka?
Hi,
Hi,
thank
yes.
you.
Good afternoon. Thank you for joining us. Yes, may we please invite you to give your opening remarks? Thank you very much. Attorney Asaoka, there. Okay,
Yes,
we can see you again now. Yes. Yeah.
just a moment. So, thank you so much for your invitation. And then I will introduce the Japanese. So, how difficult is in litigation in climate change? And we are now still fighting to this situation. So, I will introduce the Japanese situation, and then we have had so far four cases, uh, so-called climate litigation, maybe. All of them regarding the coal-fired power plants in Japan, three sites, and two civil cases and two administrative cases. Almost all of them was almost failed, and one is still now in the Supreme Court, and one is in the civil case is in Osaka High Court. So why we have been targeting the coal-fired power plants? This is due to the policy of continuing thermal power generation in Japan, especially coal-fired power plants. Maybe it's unbelievable, but this is the reality. So Japan has not declared a phase-out year of coal-fired power plants. Only one country of G7 countries after the Paris Agreement. And then even though as many as 10 gigatons of new coal-fired power plants were established, constructed, and now just started operation. New and existing coal-fired power plants until 2050, they said, government also, with ammonia co-firing and CCS. And also this plan towards the Asian country from Japan. Then this figure shows the new coal power plant, USC, and ammonia co-firing in CCS. Yeah. Then one more problem: why the climate litigation is less common in Japan, and there are only few cases? The deficiencies in legal infrastructure supporting climate change litigation may be the worst country in the world. Such a legal situation, lack of the constitutional and many climate policy and energy policy is so much weak, and far from the 1.5 degree. And you can imagine the AUKUS convention are not applicable. Environmental NGOs have not standing in the court. And no class action and lack of opportunity of citizen participation is very closed. So therefore, the coal-fired plant case, the civil case, the Kobe district court, the civil case. So the decision in almost dependent argument was adopted. So then the court did not admit the right to sue, and the court did not admit the injury or damage for people, plaintiffs also. Cause of these special coal-fired power plant, the causation is very weak. So, and then mainly this matter is to be concluded. So, this matter should be left to the political issues. Then, this is court decision, and then the administrative cases also, and the Supreme Court denied the standing of people. So, it's a long, you can see that this is almost argument from the defendant, usually is they admit this defendant's argument. So, but the Osaka Supreme Court noted, lastly, the last one, simultaneously, we do not deny the possibility of the substance of the interest not to be affected, the interest not to be affected by CO2 emission may be determined and recognized as a personal interest in the future, according to the social changes in Japan and abroad. We issue this judgment on the premise of the current social situation, Japanese society, Japanese social situation cannot. So that's this argument. And then we are now thinking the new litigation in this regarding the climate change, that structure also of thermal power phase out when, how to. Then we are thinking the factor the plaintiff, it should be used. Visibility of climate change impact of agency of take action, no. And the defendant in Japan, the major thermal power generation accountable for 30% of the CO2 emissions in Japan. Overcoming a drop in the ocean argument. The legal basis we find it by the civil tort court 709 articles. And then a scientific and consensus-based emission and reduction target a number, the degree of the reduction target regarding the IPCC or alcohol, etc. And then point in this litigation point in the question is in Japan, particularly, maybe the issues in particular is Japan, mainly, and then someone and South Korea, only two countries in the world. What is unabated coal-fired power plant? What is it? Co-firing with ammonia is abated, and then high efficiency coal-fired power plant is abated. The government says this is that is our situation. And then shifting public opinion domestically, how paralleled global common sense in Japan as island nation, small island nation, particularly in the language, Japanese language is very small island language. So then, and at last one, And then, therefore, lot of greenwashing advertised by energy-related companies. They are advertising zero emission fire power plant. It's unbelievable imagination. But they are advertising such a thing. Then, therefore, this is also the lack of the legal system to prohibit these advertising. So, and then we must fight the many issues of we have so much difficulties all round of closing the climate change litigation. So thank you so much. Sorry, I can't hear.
Could you hear us now, ma'am?
Thank you.
Okay. Okay. We will get back to you, ma'am, during our panel discussion. Thank you very much again, Attorney Asaoka. May I now-
Attorney Grip, if I
Yes.
may, I would just like to inform the panelists and the participants as well that Shri Ritwick Dutta is now online.
Okay, thank you. Hi, Ritwick. I hope you can hear us. I will turn to you.
Yes, I can hear you.
Hi, Ritwick. Yes. Okay. I will get to you after Professor Don. Okay. Professor Donna said that you can go ahead, Ritwick. Ritwick, could you hear us?
Yes.
Hi, Ritwick. How are you? Please go ahead with your opening remarks.
Sure. So, what I want to basically share is the challenges that come in Suing corporations itself. Climate change is yet to figure prominently in environmental litigation, and my experience is largely from India and a little bit from South Asia. Today, most of the environmental cases, as previous speakers also highlighted, focus on pollution, deforestation, compensation for environmental damages. This is where the focus has primarily been. And today, if you look at it, almost like 98% of the litigation actually concerns these three basic issues. It's either pollution, it's deforestation, compensation for damages that have been caused. Climate change, even as per the latest report on climate litigation globally, in case of the global south, it still accounts for only about 8% of the total litigations on climate that is happening globally. Now, even if we have a different voice so far as whether it should be 8%, 15%, the fact is it is a very small proportion of the cases that are there. With regard to the issue of standing, I think at least I can share with many jurisdictions, including India, that the issue of standing has largely been resolved, where the courts have usually taken a liberal view when it comes to standing on environmental matters. So the locus standi has been liberalized, which allows individuals, organizations who are not even directly impacted or who do not need to show how they're directly impacted, affected, or concerned to raise environmental issue because it concerns the society at large. So I think that is a hurdle which has largely been crossed. There may be instances where the courts have become very conservative or has taken a very strict, limited view about what is locus standi. But by and large, what I see is today that the issue so far as standing is concerned has largely been addressed in most jurisdictions. There are still challenges there. Now, what I see as a major challenge when it comes to suing corporation and taking them to court is, again, environmental litigations have largely focused on state and the government which is mainly responsible for pollution. Now, even if a private entity has polluted or is responsible for the destruction, usually the primary respondent has been the state, where the state is held accountable for its inaction. So therefore, there needs to be a complete change, at least a significant change in the way in which environmental litigation is viewed, where it is focused on the inaction of the state in carrying out its statutory duties, to one which holds private and government entities, including corporations there, whether it's by the government or with private entities, responsible for the environmental violations that are there. Now, that is an issue that is there, which I think needs more development so far as at least the global south. Now, what I find is that climate change litigation in the global south is fundamentally different from the global north. While the north focuses majorly on mitigation as a tool for legal action, in the global south, the focus has been and will be largely on adaptation and resilience. The role of corporates in adaptation and resilience cannot be seen independent of the role of the state. In such a situation, suing corporation also implies suing both the state. The major hurdle that will come in suing corporations in climate change, at least in the Indian context, is the lack of legally binding commitments for climate action. Now, this is important because most of the action on climate is based on policy decision of the government, which is not normally legally enforceable. Climate change remains a policy objective of the state and is not legally enforceable, where citizens can hold the entities accountable. It is for this reason that most climate change related litigation has ended up more with obiter dicta, which is basically the court expressing an opinion, a view which does not really carry any legal weight. And I think that is where it has been, that climate change is part of almost 70 to 60% of judicial decision, but it has no value, legal value, because it's largely an observation by the court and not necessarily a direction. What I see as challenge there is that unless and until these international commitments translate into domestic litigation, domestic legislation, it is unlikely that litigation by itself will succeed, because a lot will depend on the discretion of the court as to whether it wants to interfere or not. What I see here as a major challenge in suing corporation, especially private corporations, is the fear of slap suits against climate litigators. We have seen it in recent time in India. It is in other countries of the world also, where corporations file counter suits, counter cases, and often the state supports the corporate entities in doing various kinds of different kind of litigation actions under different legislations, whether it is foreign funding, whether it's domestic funding, whether it's as a charitable trust, whether it's under the Income Tax Act. So this is one which is going to be the major deterrent of for people, of organizations, of NGOs actually filing climate litigation, so far as the fear of slap suits. And that is something that has become a hard reality today. And this is something that is going to be a major hurdle when it comes to it. Finally, I think there is some ray of hope. The Indian Supreme Court recently gave a landmark judgment in what is called M.K. Ranjit Singh versus Union of India, which highlighted a very important aspect, that every citizen had the right to be free from the adverse impact of climate change. It is the first time that the court held that environment not only impacts the right to life, that is the right to clean air, clean water is part of right to life, but it also impacts the right to equality. And especially for marginalized communities, women, forest dwellers, it affects them adversely. So the right to the free from the adverse impact of climate change, and the court also took into account the fact that there has been a global surge in climate change litigations, whether in Europe, whether in Pakistan, whether it's in Bangladesh, many other countries of the world, there is a one. And the court actually recognized that the Indian courts and many of the courts globally will have to be prepared to see more such litigation on climate coming before the courts. So this is one. What shape, color it takes will depend on the kind of litigation that happens. But I see that there are still a lot of challenges and hurdles in the way before climate change litigation becomes a major part of environmental litigation. Thank you.
Ritwick, for your opening remarks. You brought up several important points, not just about standing, but I think significantly you said that we need a significant change from the way, from how we target states as the respondents and now go after corporations and other entities. And also about the issue on SLAP, or strategic lawsuits against public participation, which we'll try to touch upon in the limited time that we have so many issues, but we'll try to make the most of the time of this esteemed panel. Without further ado, I may call on Professor Donna for
Okay, thank you, Mr. Chairperson. I submitted previously a statement, but I also received 7 guide questions. So I don't know if that was circulated. I received 7 guide questions, so I'd like to answer the 7 guide questions. Apparently, I won't have time to really discuss them later on. So the first question really is about suits in the Philippines as framed as climate change-related action. So my answer there is it difficult to file cases against businesses or corporations in the Philippines? The answer there is no. We can sue them. In fact, they have been sued, and some of them have become liable, have been declared accountable for environmental damage. What distinguishes the failed environmental cases, mostly high profile, with the rather not so publicized successful environmental cases, is that the successful cases show a cause of action. So I think you've heard the other lecturers, especially Senior Associate Justice Marvic Leonen, telling us it boils down to a cause of action. So if you want to win a case, whether environmental or not, make sure you have a cause of action. So how is a cause of action determined? It's determined by evidence. So it goes there. So second question, how helpful is OPOSA in the concept of intergenerational responsibility? Does it fit nicely into climate litigation theories? So my answer is, first, let us correct legal history. Intergenerational responsibility is a state policy of the Philippines as early as 1977 by virtue of Presidential Decree 1151. So all government agencies and offices already adhere to the concept of intergenerational responsibility. And that PD 1151 was 16 years before the OPOSA decision was promulgated. And it was 10 years before the Brundtland Report of the United Nations Commission on Environment and Development defined what sustainable development is. Now, sustainable development is now called SDGs as a policy, includes 3 elements, and one of them is intergenerational equity. Okay, now the next question is I'd like to mention through there, what about the Paris Agreement? The Philippines is a signatory to the Paris Agreement, and therefore we submit compliance reports. And who submits that? I think it's whoever is assigned, but it's the NEDA that actually makes sure, National Economic Development Authority, makes sure that whoever is in the administration, past and now present, must incorporate all 17 SDGs in the medium term, in the Philippine Development Plan. The Philippine Development Plan, if you want to check if they are complying with the SDGs, can be seen on the internet. You just open the NEDA website and look for SDG Watch. Then you can choose which of the 17 you want to check. Some of them, maganda compliance ng Philippines. So we have good compliance. Some were really failing, very poor performance. But overall, I think we have a good compliance with the SDG Watch. Then going back, since I was talking about the Oposa case, I want to reiterate what Senior Associate Justice Marvic Leonen said earlier. Because the question given to me is, how does the Oposa concept of intergenerational responsibility fit in climate change litigation? Justice Leonen, in the case of resident marine mammals versus Reyes, said this: the danger in invoking Oposa versus Factoran to justify all kinds of environmental claims lies in its potential to diminish the value of legitimate environmental rights. For law students who are here from the UP College of Law, you probably know Professor Dante Gatmaitan. He also published 2 articles analyzing the Oposa doctrine, published in US law journals, and you can read it there, where he dissected what really is that case. So I would say, let's not talk about Oposa on intergenerational responsibility. If you want to talk about that, read the law. Diba? Legal research yan eh. Primary source, Presidential Decree 1151. No need to interpret. It's there. Okay. Third question, jurisdictional challenges. Do we have that? Well, we go back. Sabi din nga ni Justice Leonen, go back to the basics. We have the rule. How do you determine court jurisdiction in the Philippines? Basically, if it's about damages, then it's the money claim. Magkano ba? We all know how much is the cut-off, the limit for municipal trial courts. You go to the regional trial courts. But it's not just money claims that determine jurisdiction. We have special laws. If in the Philippines, there is a law on pollution. So if your case, no matter how much damages you ask for, if you complain about pollution, don't go to court. That case will be dismissed. Why? Because there is a law that says all pollution cases must first be filed with the Pollution Adjudication Board. There, they have the expertise. And I think, I probably think it was also Justice Marvic Leonen who said it. The reason for this, it's really the doctrine of exhaustion of administrative remedies. Why? The experts are where? The environmental experts are there at the DENR, at the Pollution Adjudication Board. Justices have no background to determine if there really was pollution. Okay, next question is about climate litigation. Is it becoming dismissed or failed because of a political question doctrine? I go back to the lawyers handling it. If you say climate litigation, that's adversarial, meaning you've reached a point where it's this or that. But it can be judicial, it can be still quasi-judicial. So kung may quasi-judicial or administrative remedies, you have to go through that process. How do you know it? This is where your legal research, so parang kinakausap ko my students there, this is where you go to research. You don't just read the law. Read what? The implementing rules and regulations. They usually have regulation number, administrative circular number on how to file cases on this. Read that. It tells you how many pages, the time, the period, what to allege, what to attach, because evidence is important. So there. Number 5. Konti na lang, sir. How about, why don't we just file it in the Supreme Court? Justice Leonen is not the only one who has been saying this in their decisions. Justices cannot make judicial legislation. The Philippines adheres to the separation of powers. We have 3 branches of government. If it's a discretionary act, meaning I can't find it in the law, it's discretion, go to the executive. If it can't really be found anywhere, go to your senators and congressmen. But if it's in the law, yes, go to the justices. But they will not do any judicial legislation. Now, the next one is the question on class actions in climate litigation. So here, I really think we are fortunate in the Philippines. We have the rules of procedure for environmental cases issued by the Supreme Court. And it tells us that there is actually a citizen suit outside of or other than a class suit. Class suit kasi can be a tax class suit. But in environmental law, there is another option, and that is the citizen suit. All you have to do is read Rule 2, Section 5 of the Rules of Procedure for Environmental Cases. Or you may want to read an older issuance, which is the Clean Air Act. The Clean Air Act already talks about citizen suits. There's also the Philippine Ecological Solid Waste Management Act. So I disagree that our framework is inherently unworkable. It's there. We just have to read the laws and the rules and regulations, and we can see how we can file citizen suits. It has become more flexible. The Supreme Court allowed it to be more flexible. Number 6, what types of defenses have you encountered in climate suits? So this becomes more personal to us. Are there difficulties in responding to them? Since I am the supervising lawyer of the Clinical Legal Education Program of the UP College of Law, we have what we call an environmental litigation clinic. So when we talk to people and we tell them their rights and they tell us, Attorney, ikaw na ang mag-represent sa amin, or Attorney, please represent us. We cannot say no. What do we tell them? Please go to the UP Office of Legal Aid or go to the Office of Legal Aid at BGC campus. We have our own environmental litigation room. And there we can interview them. We can help prepare their judicial affidavits. We tell them their rights. And we also tell them, because this is litigation, which is part of the responsibility of a litigation lawyer, is to tell your client, I'm sorry, there is injustice here, but the rules will not allow us for several reasons. One of them could be prescription. The other is we don't have the proper evidence. What you're telling me will not suffice to have the case proceed in court. Or there's a better remedy. Let's just go to this particular office that you're complaining of, and let's file this different document. Or let's go straight to the corporation. We've done 2 cases where we went straight to the corporations, and we had a more speedy reaction to the request that we made. So that's what litigation lawyers should do. To tell your client also, diretsohan din, can you give me this? Can you give me that? And then they will tell you, yes, attorney. And sometimes they have a magic bag where they will open it, and lo and behold, you have 30-year-old documents, tattered documents, photographs. That's evidence. And they have it. All you have to do is ask. Okay. 6, that's it, no, di ba? Yeah, okay. So my last question, attorney. What changes should be introduced in our rules of procedure in environmental cases? So Attorney Jackie was here earlier. Jackie is ad hoc secretariat of the UP College of Law. We were asked by Senior Associate Justice Leonen a year ago to review the rules of procedure for environmental cases and recommend changes or anything that we think. And in the initial discussion, from my end, I was thinking of 2 provisions of the RPEC. One is on the writ of Kalikasan. The writ of Kalikasan, which is unique to the Philippines, is a relief where you file for a writ of kalikasan to disclose, because what you have is some evidence of damage, but you cannot link it to that corporation. You ask for a writ of kalikasan because the Supreme Court can issue a writ of kalikasan to order that corporation to disclose the scientific evidence, and there you can now see if you are able to link it to them. And this was successfully done in the West Tower condominium case. No? It's tied to the precautionary principle. Now, what is it that I want to revise or amend there? There is a colatilia. The environmental damage must be of a magnitude that will threaten or actually harm the life or property of inhabitants of 2 or more cities or provinces. Now, since we are an archipelago, you are very familiar, we have island provinces. And Attorney Jerty is probably facing this problem. How many cities do you see in Palawan, and how far apart are they? Where is the next province of Palawan? You can choose what, Mindoro or Batangas. That's too far. How can you prove damage in Palawan that will reach this area to comply? So if you file a writ of kalikasan, dismissed ka dyan. It doesn't comply with that rule. So the Supreme Court can actually amend that and say it should be a different requirement for island provinces. Now, the second one, which is my last, is the SLAP suit. Justice Leonen also mentioned this. We now have the SLAP suit in environmental cases. Now, SLAP suits in other countries are about libel. No, because NGOs will expose things about corporations, so they're sued for libel. Dito, it was a health issue. The libel case filed against a doctor who exposed a health issue. But what I'd like the Supreme Court to consider is the reality that law enforcers, when I worked at the DNR, I had foresters, forest guards, ending up in jail. And I was asking, why are they in jail? They stopped an illegal logging operation. And then, so why are the forest guards in jail? They were charged with what? Grave threats. Theft. Why theft? Because they hold the truck full of logs into their compound. The truck owner filed theft. Will the DANR lawyers defend them? No, because that's theft. Has nothing to do with this. Grave threats. Why grave threats? He used a gun. What else? He was charged with murder. Why? He killed 2. How did he kill 2? There were 9 armed men who went into the compound to retrieve the truck. There was a firefight. He defended himself, killed 2. Murder charges. He was taken out. He had to defend himself. So ended up in jail. May pang-bail ka ba? Wala, di ba? But after going to the Supreme Court, and we should thank Attorney Tony Oposa for this, hinabol ni Attorney Oposa sa Supreme Court, the case was he was acquitted. Now we have the SLAP suit. So I think the Supreme Court should include in the rules of procedure to inform our law enforcers. There's now hope for you here also in the rules of procedure, that if these cases are filed against you, you can immediately file that this is a SLAP suit and move for the dismissal of those charges. Now, the thing that's happening now is they are charged with human rights. So I think we should work with the Commission on Human Rights to please, this also includes police officers, because when we apprehend violators, especially of fisheries laws, the apprehending officers are police officers. So si police officer natatanggalan ng pensyon, or kasi pag magre-retire na, oh, I don't want to file these cases, attorney, I'm going to retire in 2 months. tell them that you can file these cases. You can sign this endorsement to the fiscal because we now have SLAP suits. So yun lang po.
Thank you very much, Professor Donna. Um, Thank you for preempting our discussion, for already starting our panel discussion. But before we jump to our panel discussion, unfortunately, Judge Jesus Torres could not join us this afternoon. I would have wanted one judge to be in a panel full of lawyers and litigators, but he has kindly sent his opening remarks, and if you will allow me to read them. So this is from Judge Jesus G. Torres. The UNFCCC defined climate change as change of climate which is attributed directly or indirectly to human activity that alters the composition of the global atmosphere. Many studies have been identifying certain sectors of the human global economy that significantly contribute to climate change, particularly since their processes emit the three largest greenhouse gases, namely carbon dioxide, methane, and nitrous oxide. Stated otherwise, climate change is understood as being caused in one country, while their effects, such as extreme weather events which threaten human life, property, etc., could be felt in another. Having in mind our objective today to reflect on how to maximize the judicial processes to further clarify rights and obligations within the context of climate-related litigations, it is notable that the Philippines has in place environmental laws, both substantive and remedial, which are categorized under the domain of categorized under the domain of criminal prosecutions, civil actions, or admin complaints. Such laws have defined the acts and omissions, whether by natural or juridical persons, that are considered violative of the right to a balanced and healthful ecology. Notable, however, is the current legal framework of having specialized administrative quasi-judicial bodies, such as the Pollution Adjudication Board, to take cognizance of causes of action anchored on the right to a balanced and healthful ecology. A court action involving the determination of the existence of pollution may not be initiated unless the PAB is so determined. I think this is what Professor Donna was also saying. Engaging the PAB and other similar agencies is one way forward to instill proper consciousness in efforts to address climate change from a legal and adjudicative standpoint. At any rate, concerns from civil society unfolds that there remains to be lasting first impressions on certain agencies of government that are not fully implementing their legal mandate to protect the environment. That is why petitions are filed for the issuance of writs of Kalikasan and continuing mandamus. Stated otherwise, specialized agencies of government other than the courts are deemed important. They are certainly important no less in ensuring that adjudication of legal rights and obligations are protected and enforced within the context of climate change. Nevertheless, in the Philippines, there is no crime when there is no law punishing it. Criminalizing acts or omissions within the context of climate change is certainly a question of policy, and criminal jurisdiction is territorial. There are indications that it is the state policy to penalize the president, manager, directors, trustees, PCO or pollution control officer, or the officials directly in charge of the operations of a corporation or of a juridical person for violating penal provisions of environmental laws, for example, the Clean Air Act. Thus, advocates who would see the need to hold accountable certain natural juridical persons for the adverse effects of climate change also resort to civil actions for damages, where the quantum of proof is lesser than one beyond reasonable doubt. The burden of proof, however, remains with the plaintiff advocates. It is only discretionary for judges to take judicial notice of matters which are of public knowledge or are capable of unquestionable demonstration or ought to be known to judges because of their judicial functions. To my mind, climate change, its causes and effects, is a phenomenon of public knowledge, capable of demonstration, but expert witnesses and admissible evidence on causation must still be calibrated during trial on the merits of a case. Those were the words of Judge Torres, not my own. Another way forward is to re-examine the rules on evidence that should apply in climate-related litigations. And the first question to ask could be, whether or not the burden of proof, except in criminal cases, of course, could be shifted to the defendants or the respondents, who are known in the scientific community as significant contributors to climate change. To my mind, there exist in the Philippines considerable opportunities for the adjudication of climate-related causes of action, provided they are still anchored on existing legal premises. We need active and creative practitioners to bring these cases to court to move the system further to a desired status. Thank you for your kind attention. So those were the opening statements of Judge Jesus Torres. Okay. So thank you, Judge Torres. And I think Judge Torres raised some critical points about evidence and also about what Professor Donna was discussing about the need to resort to exhaust admin remedies before we go to court. Okay, so without further delay and in the interest of time, we'll move forward with our discussion with the panel. Professor Donna already brought up some of the questions, but what I'd like to do is I'd like to start by answering probably a question which is the elephant in the room, you know, and it's the topic of our panel, courts. So going to court, you know, and my first question is, and perhaps I could ask Attorney Asaoka first to answer, and maybe Professor Donna to answer as well. Why go to court? You know, why do courts matter for environment and climate litigation? Professor Asaoka, if you may answer that question. Why are courts important when we talk about climate litigation?
Me?
Yes,
Yeah.
Professor, yes. Please go ahead.
Thank you so much. So, as I said, I talked in Japan, the political situation and the climate energy policy is so much we from the citizen side and the NGO side, we cannot expect it to change by the government or policy making process inside the government. And then in Japan, the statute is law regarding the climate change protection is almost nothing. Yeah, you cannot understand. Yeah, and then government decided with the big business sectors. then, and then we have the only way. And in addition, the public awareness is also weak by the media, weak contribution. Then, and it is necessary to. We think the government reduction, in Japan, the emission reduction should be so obligated by the court. Yeah, okay. This is the obligation should be the legal obligation. Okay, and voluntary commitment, not voluntary commitment to the legally obligation. So, and then there is the only way to and only way is we go to court. That is, we go to court. So then we are now trying to get another new cases. So, and then in this by this, then we hope to change the public awareness also. Yes, that is we are trying to. So, okay.
Policies fail, and when government policies do not lead to awareness about environmental issues, that's why we need our courts. Professor Donna, do you agree, or could you add why do we go to court for these climate cases or for environmental cases?
We go to court if the law says that is the remedy. So, for example, we have 3 pending cases, and we will eventually go to court. But what we're doing at this time is, one, we are going through the administrative procedure to exhaust administrative procedure, because the law itself says it is only the government that can make the final action to remedy the situation. And so this government agency will have to file the case for our clients. So we're working with that agency, give it all the evidences so that that agency now is able to file the case in favor of our clients. So the law says this is the way to do it. The other one is there's already flagrant violation of the law. And sometimes even the government enforcers are victims. So it's not just our clients. So may private client kami, we have private clients, but they're also public law enforcers who suffer the same fate. I don't want to mention the cases, but so both. We're not going to represent the public enforcers, the law enforcers. We're representing the private citizens that were involved in the incident of environmental destruction. But so we are working with them. So we file for the private, the government will file for their law enforcer. So we still look at the law that applies, and then if it says there that the final remedy is go to court, yes, especially to impose fines, penalties, of course, exhaustion of administration. If they don't want to cancel, then you go for grave abuse of discretion.
Thank you, Professor Donna. I think it ties in well with what you said in your opening statement that our framework is not unworkable. We already have an existing framework, and we have to work with that framework. And as you said, you go to court because that's what the law says. That's what our legal mandate is. So let me jump in, Attorney Jerty. You and throughout the day we've heard about another remedy which was filed with the CHR, with the National Human Rights Institution. Of course, throughout our session, we'll be talking about procedural rules going to court. But why not other remedies? And what prompted you to go to a non-court body such as the Commission on Human Rights, the National Human Rights Institution? And Ritwick, I'm just flagging, I will call you next, like a professor. So please be ready with my question to you. But Professor Attorney Jerty first.
Okay,
Please.
thank you, Grip. Just to reiterate, at the time when we learned about Dr. Richard, he did his carbon major study, and we looked at the rules of procedure in the science of attribution science, we believe was not yet captured by the rules, and causation theory, etc. And there was value looking into the human rights impacts. We decided to pursue that. But after the hearings and the memorandum was filed, we looked into 3 options. So the lawyers met with other NGOs, and we looked into, example, greenwashing. Can we go to the Department of Trade and Industry? And then we assessed whether the deceptive marketing or advertising can actually be a violation of the rules of DTI. But then we looked at the competence of the institution, with all due respect, to actually handle a complaint focusing on environmental issues. Another thing we explored is the SEC, Security Exchange Commission, on mandatory disclosures. So because right now there's a mandatory reporting on sustainability framework by corporations, would that be a track that we can also consider? Plus, under the Corporation Code, the Board of Directors are duty-bound to inform their shareholders and stockholders of the risks that
Directors' duties.
Yes, of the risks that their business operations can lead to. But then we also assessed that it was still fairly new. But that's something that we can consider. We also looked into civil law, whether Articles 19, 20, and 21 of the Civil Code will be an option, or Article 23, including and others like environmental tort. Okay, that is something that needs to be studied, plus a writ of Kalikasan. of course, we need to amend. Again, with due respect, we need to consider the 2 cities and 2 provinces. And there's also international grievance mechanisms that are also being considered, because many of the petitioners and committee partners are saying that we have to really go to court. And to respond to the question of why is it important to go to court, because we want to compel as well, among others, government agencies to perform their mandates. I'm reminded now of a case against DOE and DNR involving coal plants. It's pending before the Supreme Court now. Modis aside, we partially won against DOE because they were compelled by the court to implement green energy options and the Renewable Energy Act. So there's the value of going to court, among others.
I think it ties in with the legal mandates. The legal mandates not just enforce, when there are violations, but at the same time there are mandates for them. There are active duties for them. Now, Ritwick, if I may turn to you, and for some of you may know, India is a jurisdiction which has a quite unique environmental system, because it doesn't only have the judicial or the court system, but it also has a specialized tribunal, which is the National Green Tribunal. And I know, Ritwick, you are a regular at the NGT. I think you were probably there before our session started. So tell us maybe a bit about the NGT, and is this a better alternative than going to court? Should we go to specialized bodies like a green tribunal, or maybe in parallel? From your experience, what do you think? And this is in the context of corporate climate litigation, of course. Yeah, please, Ritwick. Thank you.
Yeah, thanks. See, what I see that till now, the NGT has not been very promising so far as climate litigation is concerned. There were 2 to 3 cases that were filed, some of them by children, who actually filed saying that India is not complying with its commitment under the Paris Agreement. To that extent, the NGT was actually quite negative and stated that this is within the policy domain, and therefore the tribunal, which is basically a court with very limited jurisdiction, cannot really adjudicate on an issue with respect to climate change. Now, this was 2017 and 18, right? And somewhere around 22, the Supreme Court actually passed a very landmark order, Ankita Sinha's case, where the Supreme Court said that actually the NGT has to take a proactive role when it comes to climate change. And it cannot wait for even petitioners to come before the court. In fact, it has what is called suo motu powers. That means it can, on its own, based on news reports and others, take up issues, even if nobody is approaching the court directly. So actually, the judgment is interesting. It says, well, waiting for Godot cannot take place when it comes to environment. The courts and the tribunals cannot be passive spectators when an issue like climate change is coming. So therefore, to that extent, I see that the NGT does offer a scope, especially in light of 2 important decisions. One is the Supreme Court judgment giving them suo motu, which specifically records the issue of climate change is not where the courts can be passive spectators. Second is the case of MK Ranjit Singh, which I referred earlier, where they said the courts should be ready and the tribunals also should be ready for more and more such cases to come in. But I think where the issue comes in is what should be the language of cases and what should be the nature of pleadings that are coming before the court. And I think that's where the role of lawyers and others, petitioners, become very important. Now, I'll give an example. Say it's a mangrove. Now, what is traditional litigation? Suppose mangroves have been cut. We will argue saying, well, there's destruction of mangrove. It affects livelihood. It affects biodiversity and ABCD. How that same case can become a climate case is when the language or the arguments are changed by stating that mangroves are the first defense when it comes to cyclones. It is one part of building resilience, and therefore removing mangroves not only impacts biodiversity, but it makes the coast much more vulnerable in light of the fact that the coastal areas are becoming more and more vulnerable to climate change. Now, to that extent, I think it's the duty, not only of the court, but also of the tribunals to actually consider these cases as climate cases. So when you look at, say, is there a heat action plan? So there is none, or whatever that exists is too elitist. So do we have norms which regulates the working of laborers during the peak heat time? Now, these are issues which definitely can go to the tribunal. It has not gone is another fact. But the fact is, the tribunal, the NGT has jurisdiction over any substantial question relating to environment which affects the community at large. And therefore, I see a great scope of the tribunal adjudicating, giving orders for restoration, giving orders for mitigation, giving orders for many other regulations which can actually deal or lessen the impact of climate change either through the mode of adaptation and resilience. So my answer to your question is that as of now, it has not been a very active body for climate issues, but I think the tribunals and especially the NGT has great potential as opposed to constitutional courts which are burdened with so many litigation on so many diverse issues that it actually ultimately needs a specialized body. But it'll need a lot more effort, both from the court tribunals as well as from lawyers and petitioners and organizations to come with those kind of evidence before the court. Thank you.
You raised some critical points about the importance of framing an environmental issue within the context of climate justice or the climate crisis that we are facing right now. But at the same time, I think from your experience, and I've known you for probably close to over a decade now, Ritwick, and you have been one of our speakers in previous events who talk about that jump from environmental litigation to climate change and climate litigation, which I think lawyers, legal professionals, and judges should anticipate, right? Okay.
Right.
So thank you, Ritwick. We'll try to touch upon some of the other points which you raised earlier. Now, if I may turn to Attorney Ryan, to Rosé. Ryan or Rosé? What do you want me to? Either okay, any. But if I may turn to you, we're talking about courts, and one of the common challenges which litigants, petitioners, and lawyers face is the slow grind of courts. Some say it's too costly, others will say it's buried in rules. Do you agree with these points? And maybe you could share about your experience, the cases that you've handled with LRC. Do these challenges make alternatives such as Attorney Jerty discussed not just the CHR but SEC, etc. All these other remedies as more palatable than going to court?
Well, I think going to court has its value in the sense that, for example, I think when you're talking about the perspective of strategic litigation, that sometimes, even if you just filed a case, so just like I think in the case of Massachusetts versus EPA, wherein the court, I think if I remember correctly, the court said, this is a political question. Nonetheless, that actually led to the issuance of guidelines. So that is the importance of that particular case. So, and that really is, for example, the importance of going to court. Now, with respect to your question on the difficulties and challenges faced by the communities, definitely, and really it's an access to justice issue. You're going against, for example, if you're talking about a climate case and if you want to go against fossil fuel companies, and then you have, for example, several plaintiffs who are, belong to, one island. So a lot of things you're talking about, very simple things like language barriers, a simple example. Now, if you're talking about, for example, an action for damages, how do you quantify it? How do you quantify actual damages if these people actually don't keep receipts? So those are challenges, no? And then also the thing about, it takes a lot, no, for communities to actually participate in cases. So, especially those who actually hardly have enough to buy food. So if they participate in cases, this actually entails commitment. But this commitment also means that they can't work for a day, right? So those things, and I mean, you have to amplify it. These are several layers of issues that when eventually you're talking about litigation that takes years, a lot of people actually lose interest. And this is, I'm not only referring to, for example, a climate litigation aspect. I mean, envy case in general. All right. So in one of the cases, I think with Attorney Jerty, we already had 60 plus plaintiffs, which was reduced to 30 plus. Because I mean, a lot of them actually lost interest. Yeah. And died.
Yeah. So these are just really some of the realities, not just of the court processes itself, but the challenges faced outside of the court, even before you get to court by litigants.
If I may add also, talking about evidence, for example, a lot of these things. So, for example, the DNR, they have this issuance, that any submission by this particular corporation or corporations of this nature fall under confidential business information, which they can provide to you. So, I mean, how are you supposed to overcome that? I mean, those things that these are, in a sense, you are privileging business information over what? The right of the people to information. And in a sense, it also involves a democratic right, which is what? Participation in decision-making processes.
And I think this point was. Please go ahead, Attorney Judy.
No, just on the difficulties, access to environmental impact statements. Example, EIS of coal plants. We have been denied access for the last 3 or 4 years. What does the DNR-EMB say? Because it's covered by their charter and is exempted, even for mining companies, because they're saying there's private, confidential information. So we really need to engage them further. And the second challenge is the pool of experts. Environmental cases really involve a lot of science. So whether it's fishery, forestry, wildlife, smuggling, mining, or even climate, you definitely need to have your pool of experts, whether it's an hydrologist, biodiversity specialist, and that's actually a challenge for communities because there are costs involved and time involved as well.
And perhaps just to add to that, if you get the rare chance of getting a copy of the IA, how do you now go through and understand those voluminous documents? And then second, probably all the experts have already been paid or hired by by the corporations who had the EIA prepared. And I think that there's not just or go to the academia. Professor Donna, what do you think? Yeah, please go ahead.
We've done that. We have gone to the academe, mostly from UPLB and MSI, Marine
MSI.
Science Institute. She's here, isn't she? She was here earlier, couldn't make it. Yes, they've helped us with information. And there's also, our clients are able to get devices that we don't understand. We ask the experts, what is this device? And they tell us, oh, that's like this. So that's what it is. So, I mean, you just have to widen your search, siguro.
We have gone to the academe. And I guess echoing the observation, the comment you made earlier. No? I mean, of course, you're talking about, it's also a political issue. Your experts who actually render service to these corporations as well. So if they, I mean, some of them, I wouldn't say all, right? But if they actually testify against these corporate interests, then it affects them on a personal level. Yeah. So, yeah.
They will lose
But we
future
have,
contracts.
we have actually gone to the academe. And we also have gone to the DNR. But what we are saying, insofar as access to justice is concerned, is that, I mean, in terms of the availability, I guess the corporate interests have more available experts as compared to the communities. And that in itself is an access to justice issue.
I think it ties in well with what Attorney Bagilat talked about earlier in the context of indigenous peoples, wherein one of the things which they need to be able to protect their rights is that access to information, to be able to access justice. Yeah. Now we've been talking about and let's segue to corporations. And you did mention about how corporations, of course, corporations are prominent when it comes to environmental issues in most cases, whether they be in the issue of fisheries, forest operations, mining, things like that. But can corporations in the first panel this morning, we heard that corporations can be partners. They can be partners when it comes to addressing environment or climate issues. Attorney Jackie mentioned that several corporations have supported the BBNJ, for example. Bryony from the Asian Development Bank said that corporations, even fossil fuel companies, are part of the climate action group, Climate 100 group. So they seem to be partners, but in the case of the issues that you've handled, are they friends or foes? And maybe I can jump to the Attorney Asaoka and then Ritwick. Attorney Asaoka.
Hi.
Yes, we were discussing about how the role of corporations, and can they be our friends or foes when it comes to climate, addressing climate issues and addressing the climate crisis? What do you think about that statement?
Yeah, sorry. Yeah.
Oh, we were saying that can corporations be our partners when it comes to addressing the climate crisis, climate issues, based on the cases that you've handled?
Yes.
Yeah. Please go ahead. Thank you.
Okay. Yeah. Yes. I can say that if the power generation company, if the power electricity company try to change to the new renewable energy electricity company. If they try to turn to the fossil fuel to renewable, then we can cooperate with these companies. But in Japan, they rejected such a position. They have a huge thermal power plant they have, and then they constructed just now. Then they try to use as long as possible and with the ammoniacal firing in Japan. In Japan's case, and then when so they try to produce the ammonia in the Asian country, maybe Australia or another country, and then they import to Japan. At that area, in the process of to make the ammonia, it's very, very, very much. It takes so much energy and emissions, CO2 emissions so high. Then this in this case, but in Japan, the another sector of another business sector try to change, and then try to try to change to the so in your rest of the world. Yeah. Of course, in Japan, there's a good company, and they try to change. And so we cooperate with these companies still now, even now. Yeah. Could you?
Attorney Asaoka. So again, in the context of coal-fired power plants, although there are corporations which try to shift to renewable energy, but of course, as she mentioned in her opening remarks, Japan has no, if I got it correctly, they have no net zero targets, so they are still heavily reliant on coal-fired power plants. Probably that's probably a mix of the policy, and that's why the businesses are still continuing on that path.
Attorney Grip,
Yes.
if I may,
Yes, please.
there's a reaction from an online participant,
Yes, please.
Naresh Prajapati. I'm guessing this pertains to something that Sir Dutta said earlier, because the question is, no, it's a reaction. The statement is MK Ranji Ching versus UOI, I'm not sure if I read that correctly, case. So this case is non-climate aligned case. It's actually about trade-off between climate and biodiversity.
Okay. Yeah, maybe Ritwick, did you want to respond to that, and maybe give us your thoughts about your experience about dealing with corporations within your expertise. Yeah, Ritwick, please.
Yes, thank you. So to the question about corporations, I think, in litigations which are climate related, the approach has to be non-adversarial. So I think, and very adversarial approach vis-a-vis corporates will not really work, because whether it is mitigation, whether it is adaptation or building resilience, the fact of the matter is that the bulk of the production today is with corporates. And therefore, even if it is litigation, there can be adversarial litigation and non-adversarial litigation. So I would say it can be partially adversarial, partially non-adversarial. It can be starting as an adversarial and can be basically seen as a joint effort, because ultimately, I think climate requires a more positive approach, because it's not just about holding someone guilty of a particular crime. And especially in the global south, where the issue of the north versus south is very, very prominent. I think my own opinion is that in certain instances, yes, it might take an adversarial approach, but in the long term, I think it's far better to look at an approach which involves the corporations in the task, because it needs money, it needs will, and it requires a long-term commitment. So therefore, whether it is corporate social responsibility or whether it is out of some environment protection fund that comes in, broadly the direction should be to use litigation as a tool in order to guide corporates in order to invest or to direct action towards climate change. Now, the problem what we see is bulk of companies honestly believe that if you start planting trees, all your problems of climate change can be solved. Well, planting trees will not solve your problem. So that is what I personally feel. Second, with regard to the comment, yes, it is a perfectly valid comment that it is actually a green versus the Ranjit Singh's case of the Supreme Court is actually can be termed as a green versus green case. So you had the commitment under Paris Agreement to increase your renewable energy, and on the other hand, you had the whole issue about protection of an endangered species, the great Indian bustard. So how does the court balance it? Unfortunately, the balancing was not done properly. But at the same time, what is important is I would go a little bit beyond the facts of the case and look at the jurisprudence that the court has set. And so far as the jurisprudence is set, the court says, well, the right to be free from the adverse impact of climate change is not only part of the right to life, but also the right to equality. And to that extent, I think it has a good precedence value so far as other matters are concerned. So far as the facts of this case is concerned, unfortunately, climate change and the commitment under Paris has been in a way used to dilute the protection that was given to a highly endangered species. So that's trade-off has definitely been there. Thank you.
Do you agree? What Ritwick was referring to a more non-adversarial approach to corporations. Do you think that will work with your experience here in the Philippines? That we don't, we don't take them to court first, but we try to work out a solution with them.
Yes, what we do is the crucial step is to notify the corporation that there's a problem, that there's a legal dispute. So the first thing is to draft that letter to the president of the corporation. So I told my students, let's not bother with the local office, because that local officer will just keep doing what he was told. So let's go to the person who told him to do this. So we draft a good letter, and immediately, this is our experience. The corporation hired one of the top firms and started asking our client to meet with their lawyers. So we told their lawyers, kasi we're all BGC. So we said, we're in BGC too. We are the lawyers of these people. So let's meet here, either in your office or here at the UP College of Law BGC campus. And then we started negotiating. And then I thought of a strategy where I thought, let's go and talk to the president, because he's paying a large sum of money to this top law firm. And I know the rate is more or less how much per page? 10,000 pesos per page. And we were told that there was something like a 200-page memorandum of that that was in the hands of the corporation. So I said, though they lost so much money already. So we started going for, under IPRA, the Indigenous Peoples' Rights Act, all you have to do is comply with the free and prior informed consent. You just ask the indigenous peoples, do they really reject your project? But you have to explain it to them. And they did. So no more lawyer there, and they started talking directly. So we didn't have to go to court. But of course, there's also several companies who really are hiding because we think they're illegal in the first place. So that's why we aligned with the DENR. We aligned with the DENR because the DENR also had not enough evidence, but know that there was something illegal. So pag ganon, when we know it's useless to talk to the corporation, we don't bother, especially if the names of the president are doubtful. So now we know, di ba? It's so easy to know if the name is doubtful or not. Maybe I can share that one instance where we thought the project would amount to something like at least 20 million, 50 million pesos. When I saw the president, she's parang na Senate hearing kami. She's probably a market vendor. So I knew that we're dealing with something that's really illegal. Then we didn't bother. We're going straight for just doing our paperwork and really going to court eventually.
Attorney Grip, just a quick intervention on that before we lose the point. One of the things that we saw in making the national report is the question of mootness. So just in general, so our jurisprudence never really gets to develop because of settlement. So no conclusion is reached by the court. Do you think that's good in general in the sense that solutions are crafted before we exhaust all court procedures, or do you think that the trade-off is big in the sense that we don't really have a stable legal framework here because of compromise?
Tony Jerty, or
Just to initiate, thank you, Professor Mike. It's, you really have to weigh. We have, like, for lack of a better phrase, cost benefit, advantages and disadvantages. Like, example, if it's the carbon majors, more than 50 corporations, I think it's a Herculean challenge to be able to really dialogue, and see because of the documented history of climate denial, obfuscation, etc. But then on the matter of whether you need to enrich jurisprudence by initiating cases, I think the legal team with the community should go through a process of identifying clear objectives and outcomes. I think a transparent process with the communities and also other civil society groups who may be involved and other even people from government or the academe would be very important, Professor Mike, so that you know what will be your options. Administrative, judicial, there are a lot of laws available. But at the same time, what outcome do you want? Example, I'm reminded of the RP Energy case that Saj talked about, where he actually reprimanded civil society. When you know the group, the coal plant, they withdraw. The case lost. It was dismissed. But just a year ago, the company withdrew from pursuing the coal plant, which is from 150 megawatts to 300 megawatts. So after all, there can be a case lost, but there's also another solution. So I mean, these things need to really be studied. So I go with also Professor Donna and Gripiat. We also need to do research. Even due diligence work involving corporations, you know, whether the carbon majors, a coal plant, mine company, or whatever company would put at risk the welfare of the community and even our climate, those are things that need to be studied. So it goes through a tedious process of really studying. There are no quick fixes in this process. Thank you.
And that relates to the case-to-case basis, but at the same time, what Jose was mentioning about strategic litigation. Even though it may be you may lose court, but you can have non-judicial or non-legal impacts of the litigation that you pursued. Yeah. I've been asked to wrap up, but maybe just one question for Jose. And I know we had a bit of discussion earlier about you mentioned about attribution, burden of proof also. Now, is science a challenge when it comes to holding corporations accountable in your experience? Maybe talk about burden of proof and causation. How does this link to the issue of causation or linking corporate action to the actual climate impact?
Well, when you're talking about, I think when talking about climate litigation, it's really a challenge. Largely because, attribution science itself is, I think, a fairly recent science. So, and then if you apply it to litigation and court action, then I think even in other jurisdictions, there isn't enough, I think, case basis to actually, to serve as a guide. But nonetheless, the science is there, and I think in one of our discussions with the experts on attribution science, you can actually quantify the contribution of one carbon major and how it has actually contributed to the climate crisis. Of course, also the other issue with that is, how do you measure damage? Do you measure the contribution to climate change or damage in terms of impacts? Because the impact is actually an inevitable consequence of the contribution to climate change. So do you have to wait for impacts to actually have a cause of action?
Or can you already hold them accountable for the
precisely.
attributable attributable impacts? Yeah. So I think these are some of the issues. Maybe perhaps in the panel tomorrow we can explore more on the remedies. Yeah. But just to wrap up the session, I think this panel could have been a 3 or 4 day conference, given the expertise that we have here. Maybe just to wrap up, and anyone in the panel can give 1 minute, 2 minute remarks. What needs to be done to hold corporations more accountable for climate change? And how can courts help in this process of holding corporations accountable where they are responsible, when it can be attributed to them that they are causing climate change? Maybe I can start with Ritwick online. Ritwick?
Yeah, thanks. What immediately comes to my mind is is that we have to attribute specific inaction on the part of the corporate entity so far as the overall climate goals of the nation is concerned. So it will be an issue of joining the dots together. So if the nation as a whole has committed to reduce its carbon footprint and its carbon, the energy mix, now if there is specific entities which are violating the same, then they should be taken to task. The second would be their action which directly impinges on adaptation and resilience. If they are doing certain action which actually makes the country or the people vulnerable to the impacts because of climate change, these are aspects on which specific corporate-centered litigation is possible and should be done. Thank you. Sorry, I'm not able to hear you with this.
You can hear us?
Now I can.
Okay. Okay. But thank you, Ritwick. We'll move to Professor Donna, if you may. How can we hold corporations more accountable?
Okay. The penalties and fines are quite reasonable now with the new laws. So if the case is already proceeding, the Supreme Court just has to impose the proper fines and penalties. But of course, to get there, we need to have our evidence and cause of action and how to determine liability. There's a new law just passed May. It's the Philippine Expanded Natural Capital Accounting System. So that will be a system, but that's been used in UPLB already. It used to be Natural Resources Accounting. So if you wanted to determine the value, not just the impact, but the tree that is still standing, they already have a formula. That was used for carbon trading during the time of President Ramos. It's still there, and that is now the PENCAS. So we're looking forward to that. There will be evaluation, not just of the impact, but of what is still in that particular resource. So I guess that.
Again, science playing its part in evidence and in law. Roset?
I think one is attribution science, no, to actually incorporate that in the. I guess in the rules of procedure. Second is we had a discussion earlier about the precautionary principle. Perhaps because the difficulty really is, the way it is couched is that, if you don't reach a scientific certainty on causality, then you apply precautionary principle. But there are a lot of bureaucratic processes before you can actually achieve that. And then you're going against the expertise of the DNR. So, but there is another articulation of the precautionary principle, which is the Wingspread Declaration, which is actually used in Africa, I think African states. When you just need to establish that, this activity will actually resort to environmental harm. And then you shift the burden to the respondent. So I guess from a practical and operational perspective, that is a better articulation of the precautionary principle.
Perhaps something more to explore when holding corporations accountable here.
Yes,
how to
yes,
shift that burden.
Yeah.
Or how to shift that
Because
burden to them.
when
Using
you-
our rules, of course.
Yeah, because we're talking about experts and just the realities of litigation. Yeah.
Thank you, Attorney Roset.
And
Gregorio?
me, Grip, I think I agree with the panelists, Ritwick, Donna, and Ryan. But there's more work to do, actually. More work to do in terms of engaging the judiciary, engaging with the executive, even probably the corporate sector, but the communities who at this time are still suffering from the impacts of climate change. How do we make sure that the updated information and the experiences, their stories, are articulated in a manner that can be captured by the courts, okay, and by the government agencies. So there's a lot of work to do, but we can build upon what exists, our laws, the studies, the carbon major studies, even jurisprudence. And I'm saying more work because you need to consolidate. And we need to make sure that that repository example of CHR can be simplified and shared because more people need access to information. So we can broaden the constituency of lawyers, advocates, professors, communities, judges, prosecutors who want to address climate harm. Thank you.
Thank you, Attorney Jerty. And with that, we wrap up this panel discussion. Please join me in giving our esteemed panelists a round of applause. Thank you very much to all of them.